A person who got lesser academic marks get higher marks in the interview. That's the only
No, but that
basis.
is, maybe there is a rider to that. That is acceptable. Your argument is acceptable. Academic marks that would not.
Yes.
But then how could so many, according to the court, get 9.5, 10?
There were thousands of candidates. Many of them did well, got more marks. Several thousand appointments are being made, 42,000. And out of them, somebody will be getting 9.5, somebody will be getting 10. Many of them will be getting. Landlord just has pointed out only a few. We are being good to them because he's unsettling a settled thing. I have a regular job in, I'm performing this regular job for last 6-7 years. And Landlord says you again go through this.
Go to the interview and that.
Yes, again interview and aptitude test.
Termination.
A completely third case has been made out. There's no pleading with regard to this. Kindly first take page 88. What are the grounds? Page 88. That the department should have acted justly, fairly, constitutionally, but they have acted absolutely illegally, unconstitutionally, etc. Then number 2, department being a statutory body should have valued the fundamental rights, but here they have flouted. 3, the department has recruited non-trained candidates after expiry of the relaxation given by the NCT, but not recruiting the petitioners. This is absolutely factually wrong. This was done within relaxation period. Now 4, board has committed a complete injustice and illegality by not publishing the merit list. 5, board has committed fraud upon the non-trained candidates and did not follow their own notification. Now 6, for the present petitioners deserve equal rights which the non-trained candidates got during their appointment. 7, mode and manner in which the respondents have acted abundantly violates fundamental rights. 8, the board has not complied with any procedure of law in acting in any manner as more fully stated here in our. 9, the respondents are public officers discharging statutory functions incumbent upon them to act in accordance with law. Then 10, any other grounds need to be taken at the head. Then kindly take page 90. The prayer portion. Prayer A, Rule 26, etc. dispense with. B, mandamus. 1, to act in accordance with law. 2, to direct the authorities to file a report disclosing name, numbers, rank, category of all non-trained candidates who have been recruited till date the primary school TET 2014, including date of recruitment. 3, to direct the authorities to treat the petitioners equally with the non-trained candidates who have been recruited by the board after expiry of the relaxation given. Therefore, they also want that they be appointed. Now 4, to recruit the petitioners by giving them the same benefit by which other non-trained candidates were recruited by the board following such and such. Then 5, to direct the authorities to publish a merit list. 6, to protect the records and documents relating to recruitment procedure and selection of primary teachers. Then Sashirai, send the records. Milord, your lordship will not find a whisper in the petition regarding aptitude test, any wrong procedure being adopted, except, milord, that relaxation period was over, appointment was given. Why untrained candidates were given upon facility like that, whereas petitioners who are also untrained were not equally treated, treat us equally. This is the entire scope of the petition. Milord, wherefrom the learned court went into the aspects, milord, that it delved in detail. Milord, what was the basis of doing this? Milord, what was done actually is, milord, on behalf of the petitioners, a compilation was submitted, unaffirmed, containing some allegations. The learned judge, milord, there is no affidavit. It was taken on record, and on the basis of that, the court started proceeding. The court directed the board to submit the list of the interviewers who had interviewed the candidates, took the aptitude tests, etc. A long list was given. There was 31 of them. 31 of them examined them. The questions were put by the court itself, and those persons were the teachers who the interviewers, they were examined. And the court was acting, I will say, court was acting as a prosecutor, as if when the matter was pending investigation before the CBI. The CBI will be looking into the criminality aspect, but criminality will depend on illegality also. Therefore, how can the lead court at this stage point out that these appointments are wrong, illegal, not following the rules? Now, what is aptitude test? Hard facts, your lordship said. What are the questions put? The point is that five marks are allotted for interview, 5 marks for aptitude test. The questions that the court was pleased to put before these interviewers was, have you segregated those marks? Kindly will not recall that this is an examination of the witnesses in respect of events which took place 6-7 years before. Some said yes, I allotted marks differently. Some said no, jointly, together. Now, what is an aptitude test? What is an interview? There is hardly any difference, as I see it, my lord. In the interview, some questions are asked, answers are obtained. In the aptitude test, also the same thing. In addition to that, my lord, the demeanor of the candidate, his smartness, whether he can communicate effectively. My lord, these are aspects which are, and whether they are able to communicate their views, because they'll be teaching the students. These are, my lord, asked from the candidates. Now, my lord, the difference is not much, and 5 marks each. Whether, my lord, the marks were allotted separately or they were jumbled up, my lord, this is, the court proceeds merely on the basis of the statements of these 30 persons, interviewers, and they are being interrogated when 6-7 years after they had sat in the boardroom to take interview. What they did they allot separate marks, or did they allow marks jointly in respect of both together? What do you mean by aptitude test? These are the questions put. Now, simply on the basis of that, the court holds the appointment to be bad.
Where are the recruitment rules?
The recruitment rule is at page
particularly with regard to training and with regard to aptitude, a lot of aptitude tests, etc.
153.
Let us see the rules.
153. 2C. Milord, kindly take first, Milord, section 2C at page 154. What is an aptitude test?
Let us see the section regarding training and the relaxation.
No, that is not here. That is in the Ministry of Human Resource Development Department. They under section 23 of the
they are part of
the Central Act. They have the power. MHRD has the power to relax the training qualification for particular periods, and here training qualification was relaxed with the condition that this is relaxed.
Just 1 minute. But that notification, relaxation, in view of the, is in the notification itself, the Parliament has taken the decision. Therefore, the central government has extended the time up to 2019. They have to be trained. Just one fact I add, writ petitioners also untrained.
True. We'll come to you, Mr. Bandopadhyay. Yes, Mr. Gupta.
Yes, Milord, the relaxation, as your lordship, Milord, put the query to me. The relaxation was granted by the Ministry of Human Resource Development Department to the state of West Bengal and some other states.
Where is the
Page
document?
135. Page 135. Sorry, 137, Milord. 137. 140.
তাহলে দুটো আছে
135.
There are two stages in which relaxation was granted. One was at page 140. This is the second relaxation. 140. This is the second relaxation. There was a prior relaxation also. আরে বাবা সেটা তো প্রথমটা কোথায়? দুটো ছিল, রিল্যাক্সেশন দুটো ছিল। Milord, kindly take page 140, Milord. Kindly come to paragraph 7. Now, therefore, in exercise of the powers conferred by subsection 2 of section 23 of the RTE Act, the central government hereby extends the relaxation to the state of West Bengal in respect of the minimum teacher qualification norms notified by NCT as published in so and so, insofar as they relate to classes 1 to 8 as under. 1 year diploma in elementary education for appointment of a teacher in classes 1 to 5. We are concerned with this. Classes 1 to 5, this is 2 year, not 1 year, 2 year diploma course. This relaxation is granted. This is a training qualification. Then kindly turn over, Lord. The above mentioned relaxation shall be valid up to 31st March 2016 and shall be subject to following conditions, namely, as specified in the aforesaid notification of NCT, the government of West Bengal shall conduct TET in accordance with the guidelines dated 11th February 2011 issued by the NCT, and only those persons who pass the TET can be considered. Therefore, though training qualification is relaxed, TET is remains compulsory.
So in other words, sorry to interrupt you, you recruited untrained
Untrained.
and then you trained them.
Yes. And
Show us where you trained them.
this notification says that the trained will get preference in the matter of appointment, and when the trained are exhausted, then untrained are to be.
There's no complaint on that.
No,
There's
and no complaint on that. And all these persons will not subsequently qualified, but that is neither here nor there. It's a question of appointment, whether given rightly or wrong.
That's right. Now then
Yes.
thereafter you
Now-
train these persons. These untrained teachers whom you took thereafter, according to the board, they got training. Where is
Got
that
training.
statement?
No.
Where have you stated that before?
These persons who were appointed at the relevant time, they were all untrained.
Correct.
And the challenge is to their appointment, not whether they were subsequently qualified or not. That's not the issue.
Very
The
well.
issue is
But then
whether-
you still gave them training and they were trained subsequently.
Yes, because the board doesn't give them training. They
So where is that
they obtain training from different institutes. Is the different.
The single bench has taken notice of the fact that they have been trained. Paragraph.
Yes, they have been trained. I do not know from where the single judge got it. But in any event, otherwise their services could not have continued.
Kindly see paragraph 22 of the judgment impute. There's something in bracket.
302.
For recruitment exercise, so candidates who were untrained at the time, now we are
At page will not
including
see-
candidates who have obtained training qualification in the meantime.
Yes,
So some of the candidates had obtained training qualification in the meantime.
yes. Otherwise, they could not have continued in sir.
Correct.
That's
So
the
if they have
condition of their-
obtained training, all that we are asking you, you know your case best. We are only asking you to give us an idea, an impression of what is happening before us.
Yes.
If they obtained a training we may be wrong, correct us. If they obtained a training qualification in the meantime, which means after they obtained the training qualification within the period granted to them by the page which you mentioned, then they have availed of the relaxation.
Of course, yes.
So they can be allowed to be enforced. They should. So that is the point. Where does it come from? The papers we want to find out.
So whether they obtained the qualification subsequently, that is
That's right. After joining.
after joining. Of course, my lord, they are not one was impleted.
Correct.
Therefore,
how
my lord,
did they-
therefore, my lord, both it is for with the respective DPSCs, the district primary school councils, to tell it before your lordship. Not a single DPSC has been impleted.
Very well. Please continue in your own way.
But the
training national
কোনখানে সেটা লেখা আছে কোথাও সেটা is it on record? কোনটা কি বলো? Exactly. There is nothing on record.
Just one minute. After that,
বলো না Joshua, বলো না।
that's just permit me.
Yes, of course.
But in my petition, I have annexed all that documents that we have got the training, got the certificate. Number one, after the certificate, we have got it. we have been giving training benefit. Number two. Number three, we were originally appointed in grade B. Then immediately after the obtaining of this certificate, we were upgraded to grade A by the board itself. All these facts in my petition, sir.
Then why did the board not place this on affidavit before the single bench?
The question, this is not in the writ petition. No, nothing. We have not been paid party.
One of the issues against you was you were were untrained. So why did the board not place it?
Kindly just may I crystallize the point? Just
Yes.
in the advertisement, it has been said, if you are untrained,
We are trying to concentrate.
just I am making.
No, you make your submission. This is not we are trying to focus on the opposite.
I am
part
coming.
of the
I am coming, Millard.
Yes.
The point which, if I have understood your losses correctly,
Yes.
in the advertisement it said, trained, first priority, untrained with certain qualification, but you have to qualify the training certificate within a period of 2 years from the appointment. Correct, Millard?
Yes.
This has been, we were selected. Then we have got our training course. We have got the certificates within the period of 2 years. Now, Mr. Gupta has shown you lots of 2015 and 2017. Up to 2015. In 2017, they sent, in my petition, it is there. Just take it from me, Miller, for the time being. 2017, the central government has said again, last time it is being extended up to 2019. All training semesters should be done within March 2019. That has also been done in our case. Therefore, the point which is really, if I am right, striking, that ultimately I have been trained, since your lordships have said this observation. Ultimately, I have trained. Papers are in my petition. I will show it. And because of the training, I got the training salary and upgraded by the board.
Therefore, no, we are not saying anything which is in the nature of expressing the final mind of the court. We are discussing all it.
All right. I am taking it that way.
We are not saying
I understand.
in capital words. We are saying in small words.
I am understanding, but I am trying to if I have correctly understood your lordship's mind,
Therefore,
possibly this is the answer.
correct. Therefore, if you come now to paragraph 22 of the judgment,
Just paragraph 22
of the impugned judgment.
Yes, I am coming. Since it is not be tallying with me. Kindly come to
Para 22.
yes.
Now, if you please read paragraph 22, the first.
Paragraph 22, yes. The board shall immediately arrange for a requirement exercise for candidates who are untrained at the time of recruitment, so and so, who have obtained so and so. This is certificate.
Now, what is the scope of this if the
Kindly take it very, very, my lord, kindly appreciate this. How many times I have to give this fire test? Does it depend? Is it depending? Is it supported by any exercise of law?
Therefore, Mr. Gangopadhyay, we stand at one point somewhere that getting a training is not an issue.
No.
Getting a training is not an issue. So that part goes. Second is now, because of the observations of the Honorable say findings regarding interview and aptitude test, whoever is there in the room, untrained and trained in the meantime, has to go through the interview and aptitude test alone.
Yes.
We'll come to that issue as we come. Yes.
I wanted to point out.
On the microphone, as much as you can take the microphone. Normally difficult to take the microphone from Mr. Gangopadhyay. Yes.
I'm very much.
Mr. Gangopadhyay doesn't require me.
The only thing that I wanted to point out is that Lord NCT permitted recruitment of untrained teachers subject to the condition that they should qualify within a period of 2 years.
They have done that.
And that has been done. So, my lord, question of considering any untrained candidates would not arise at all. It's a
Therefore-
non-issue.
Correct. So therefore, following the process of elimination, subject to this training part we eliminate.
Correct.
Now we come to interview and
Absolutely. That's the crux of the matter.
One, just, Mr. Gupta will say, Mr. Gupta has not given charge. One paragraph has been given by the learned single judge, picked up 22 cases, giving the numbers, and take my paragraph, one paragraph I will show how much number I have got. Forget about interview in an academical.
Let us see. Yes, Mr. Gupta.
My lord, as I submitted, my lord, on behalf of the petitioners, a booklet was filed before the court. Not an affidavit. In a spiral binding, some sort of a booklet was filed, some allegations, some documents, etc. were there, more than 100 pages. Now, my lord, the learned court picks up some documents from there and proceeds to deal with the matter on the basis of such documents. Some of such documents included this aptitude aspect and the further allegation that those with lesser academic marks were awarded higher marks in the
Let us
interview.
go back to the recruitment rule again to see that provision first.
Lordship.
How it should have, what is laid down in the recruitment rule. in three.
153 it starts, my lord. 153 it starts.
157.
Rule 8 at page 157. My lord, your lordships are now going into the aptitude test and interview aspect. But before your lordships go into this, I beg to remind your lordships that this is not a case made out in the writ petition at all. Not a case made out. Therefore, kindly keep it in mind, and I definitely show to your lordship what the provisions are. Kindly come to page 157. Rule 8, procedure of selection. The selection committee shall make prima facie scrutiny of the duly filled application forms submitted by the candidates having qualification. 2. The selection committee shall call all qualified candidates as mentioned in Sub-Rule 1 for the viva voce or interview and aptitude test. The performance of the candidates who will be called for viva voce or interview and aptitude test will be assessed separately by the interview board formed for the specific purpose. 3. Academic qualifications, training, performance in the TET, extracurricular activities, and performance in viva voce or interview and aptitude test shall be computed in the manner as mentioned in table A below. Then, my lord, for each separate marks and mentioned, Madhyamik 5 marks, higher secondary 10, training as specified by NCT 15, then teacher eligibility TET the 5, extracurricular 5, viva voce or interview 5, aptitude test 5, total is 50. Then note 1, the percentage of marks obtained by the candidate in the Madhyamik examination or its equivalent, excluding additional marks, if any, shall be reduced proportionately to marks obtained out of 5. Supposing, my lord, somebody gets 500 marks out of 500 aggregate. He gets 5. Somebody gets 400 out of 500 weightage. Now, my lord, note 2, the percentage of marks obtained by the candidates in the higher secondary Madhyamik examination or its equivalent, excluding additional marks, if any, shall be reduced proportionately to the marks out of 10. Same procedure. Then note 3, the percentage of marks obtained by the candidate in the relevant teacher training shall be reduced separately, proportionately. But same thing, proportionality rule is to be followed. Then note 5. No, note 4. The percentage of marks obtained TET examination shall be reduced proportionately. Then 5. Marks out of maximum 5 shall be awarded to the candidates in the extracurricular activities on the following extracurricular activities. In case of candidates applying for the earmark post as mentioned in such and such, that these are para teachers, marks out of 5 shall be awarded on teaching experience. This is regarding, my lord, para teachers for whom there is no aptitude test. Then kindly turn over 158.
Yes.
Page 158, sub-rule 4. The marks of candidates applying for non-earmarked vacancies shall be allotted as follows.
That's all right.
This is the bulk of candidates, non-earmarked vacancies.
Now, where is the aptitude test?
Aptitude, it is defined in Rule 2C. Now,
Rule-
aptitude test marks I have shown to your lordship, 5 marks.
That's
At,
right.
at page 157. At page 157, my lord, Roman, the last one in the table, Roman 7. Aptitude test 5 marks. Just before that, now Roman 6. Viva voce and interview 5 marks.
Now tell us what is the material before the single bench? The material on because of which single bench felt that 157, 158 was not followed. Show us the relevant material placed before the single bench. Where is that in your affidavit? It is recorded in the order.
Yes.
But we would like to see the pleaded material before the single bench, that why the single bench came to the conclusion 157, 158 were not followed.
157, 158.
মানে এই 157 মানে এইটা
Oh.
158 মানে এইটা
No, not followed, my lord. The only basis is
What is the material before the
material
single
is, my
bench?
lord, examination of 30 interviewers.
Show us that material. There must be something on oath, something on affidavit.
Nothing. As I said, my lord, a spiral booklet. was
Where is that spiral booklet?
spiral booklet আছে তোমার?
স্পাইরাল বুকলেটে ওটা অ্যাপটিটিউড টেস্টের কথা কোথাও বলা নেই,
সেখানেও নেই।
এটা কোড নিজে থেকে বলেছে। কোথায় অ্যাপটিটিউড টেস্টের কথা বলা আছে? কোথাও বলা নেই।
Something has to be seen, read, and then we have to.
Kindly read paragraph 14 of the judgment, paragraph 14.
That's right. 14 is there.
That's
But
right.
where
Otherwise,
does-
no other basis.
The material your lordship will find from paragraph 9 of the.
Yes, paragraph 9 I just.
See, certain,
How were they placed before the single bench?
nothing, they were called in the witness box and got some evidence that is what is recorded. Please
That's
come
right.
to page 6.
Then how did the board, according to the board, what did the board say? How did it conduct the aptitude test?
My lord, the aptitude test is taken by the interviewers, my lord, how it was conducted by each of more than 100.
So what have you
Interviewers.
stated when you were asked that question by the single bench?
Nothing is questioned. I am told, my lord, nothing is questioned.
Where is the board's affidavit before the single bench? Board's affidavit, report, whatever. Where is
affidavit?
that affidavit of the board?
টেক্সট বলেছি, কিন্তু ওটা রিট পিটিশনে অ্যাপটিটিউড টেস্টের কথা ছিলই না। আমি কি
My lord, the board's affidavit, the only opportunity we got was to deal with the allegations contained in the writ petition. Nothing beyond that.
Now, please come to page 191.
আর একটা এফিডেভিটে অ্যাপটিটিউড টেস্টের কথা
191?
Yes. There is a reference to an exception to the report filed by the board. So there must be a report for that. There must be an exception. Where is the report of the board?
আমরা একটা এফিডেভিটে বলেছি অ্যাপটিটিউড টেস্ট নিয়েছি।
আমাদের রিপোর্ট কোথায়?
তো 164 এ যান, স্টেটমেন্ট নাম্বার 164 এ আসুন।
164.
এটা আমাদের অবজেকশন।
Not the board
One
used
on page 164.
Yes, 164.
board's affidavit, my lord, are at page, my lord, 265 and my lord, 273. First affidavit at page 265. That was affirmed, my lord, in terms of the order dated 17th of January 2023,
265.
265.
এটা আমরা অ্যাপটিটিউড টেস্ট নিয়েছি স্যার।
My lord, this affidavit was affirmed in terms of the order, my lord, appearing at page 263.
We've seen that.
Kindly take paragraph 4 of this affidavit
266
at page 266.
Yes.
There is a reference to the aptitude test. Both interview as also aptitude test.
প্যারাগ্রাফ 5
Then paragraph 6.
স্যার 5
That is the 2022.
Paragraph five.
interview and aptitude test, that does not
ফাইভে কি আছে 16
detain us here.
Paragraph five ষোলো নেই।
এটা-
4 আর
হ্যাঁ।
5 ষোলো নেই। 4 আর 5 ষোলো নেই।
4 and 5, paragraph 4 and 5. This is dealing with 2016 recruitment process.
Very well, please. Then where did the honorable single bench get the material in the chart form, etc., that has been printed in the order? What is the basis of getting those materials?
That unaffirmed booklet.
Kindly come to page
Paragraph
11
9,
and 12 of the order.
page 292, my lord, paragraph 9.
Yes. Who prepared the 121-page booklet? You have a copy of the same.
That copy was supplied.
We cannot hear you.
On the next occasion, that copy was supplied to the board.
To the board. That was an unaffirmed booklet. Anyway, we'll come to you later. Yes, Miss.
Then, paragraph 9 at page 292, where, my lord, the
Yes.
দেখাবেন কি একবার?
কোনটা এটা?
But let us assume, Mr.
So
Gupta,
this is, my lord, that booklet.
yes, let us assume that this booklet, the marks that are reflected, taken notice of by the single bench are correct. 9.5, 10, 9.5 weightage. What has been the board stand regarding this before the single bench?
My lord, getting lesser marks in the academic examination does not always mean that the candidate will get lesser marks in the interview also.
Accepted.
Settled.
Accepted.
But the court went by the fact, went by the assumption that how could a person who got lesser academic marks get higher marks in the interview? That's the only
No, but
basis.
that is, maybe there is a rider to that. That is acceptable. Your argument is acceptable. Academic marks, that would not.
Yes.
But then how could so many, according to the court, get 9.5, 10
My lord,
serially in the interview?
Lord,
How did
there
the
were-
board meet this?
there were
content?
thousands of candidates, and definitely the same marks will be obtained by many of them. And many of them did well. They got
On
more
the
marks.
microphone.
Many of them did well, got more marks. Several thousand appointments are being made. 42,000. And out of them, somebody will be getting 9.5, somebody will be getting 10.
2.5 ও আছে।
Many of them will be getting.
2.5
Landlord just has pointed out only a few.
2.5 ও আছে।
There are many.
Sir, 2.5 ও আছে out of 10.
You have your records or you do not have your records? You do not
It was published with marks, all.
district wise.
No, as a whole publish হয়েছে, but selection process টা district wise.
Publication was by the board in respect of the entire state. The recruitment was done at the DPSC level.
District wise.
Not DPSC.
Yes, please continue.
Now, I was making this submission. Was there any occasion for the court to make out a case for the petitioner, which they themselves did not make? That is why the Supreme Court says, my lord, I have brought one judgment, that it's not for the court to make out a case, a third case. Now, this is what, my lord, exactly what has been done as appears from this judgment.
So what
I have
happens?
placed, my lord, the grounds on the prayers in the writ petition. How, my lord, if somebody sees these grounds and the prayers and then comes to the judgment, one will be astonished to find how these aspects are being gone into by the court. There is no amendment to the writ petition taking these grounds. And who says, at whose instance these interviewers are being questioned? being put to the box and questions are put to them by the court? At whose instance? চাকরি চলে গেছে কেন?
সে বাংলা ইংরাজি বুঝতে পারেনি তাকে ডিসমিস করেছে।
Oh, I am told that one of the interviewers who during this examination by the court could not follow the question put to him in English.
But that appeal came to us.
সেটা সাইড হয়ে গেছে।
Oh, I think that I didn't know.
We reinstated his service.
I'm grateful.
That's the only reason he lost his job, because he did not know English, and we found that he was a physical and works education teacher. So we asked for his reinstatement, but that was purely in the, as far
That's
as,
it.
on the facts of that.
No,
case.
but here we are in the present facts of the case, in respect of the scope of challenge thrown, the relief claimed, how could this order be passed? And my lord, and the paragraph 22 your lordship was referring to, there the court, what the court does is not a simple thing, my lord, that that you are not being put to the wolves. We are being put to the, because he's unsettling a settled thing. I have a regular job in, I'm performing this regular job for last 6-7 years. And learned judge says you again go through this,
Go to the interview and that.
yes, again interview and aptitude test.
টার্মিনেশন।
Yes, we come to Mr. Bandyopadhyay. Let us, everybody get an opportunity for today. We'll continue the matter tomorrow.
One more point I'll just indicate.
Please.
I have not cited a judgment on this. You know, if I may give the
Time
judgment.
has not gone also. We are here for you even tomorrow. Yes.
But kindly give me my petition's copy. Scan 2 of 2023, 890. Scan 2 of 2023. But I just, no. I tell you, Lord, sis, the point is, Lord, which was stopped initially was possibly initially, it just I assume that's was troubling to your Lord's system. Kindly come to the advertisement first.